Here's what I'm trying to understand. Why is your record so bad?
Well, I don't view it that way, Senator. When I look at the quality of my decision-making, the feedback that I get from parties,
Well, of course, parties are not going to criticize you. They want you to rule in their favor.
I understand, Senator Kennedy.
I mean, that's just the way it works. Help me understand why you have such an abysmal record in moving cases. I mean, it costs a lot of money to litigate, and people are paying lawyers, and time is money. And of all the district court judges in the Seventh Circuit, you're the worst in terms of moving cases. Why do you think you deserve to be promoted over all of those others?
Senator John Kennedy delivers one of the most devastating takedowns of a judicial nominee in recent history, exposing catastrophic productivity failures and shocking inability to defend her own legal positions. In this explosive Senate Judiciary Committee hearing, Kennedy systematically dismantles a federal judge seeking promotion despite having one of the worst performance records in the entire nation. The statistics are damning. 125 undecided motions, ranking 7th worst nationally for productivity, and 3rd worst for motions pending over 6 months. Watch as the nominee struggles to explain why her record is so abysmal compared to the 68 other district judges confirmed during the same period, who all faced identical pandemic challenges. Kennedy methodically destroys every excuse, demonstrating that while her peers succeeded, she failed spectacularly. The questioning gets even more intense when Kennedy exposes a brief the nominee signed advocating for assault weapons bans. Yet, she cannot define what she wants to ban or explain her own legal positions. Her claim that she didn't write the brief she signed becomes another example of her inability to take responsibility. Let's dive into the main video.
Judge, welcome.
Thank you.
You are probably the least productive member of your district court, isn't that right?
Well, I have not considered myself in those terms, Senator.
Well, let me explain what I mean. You have 125 motions pending that you've declined to decide.
Let
me finish. That's more than any other district judge in the entire 7th Circuit. In fact, you rank 7th highest nationally, do you not?
I am not familiar with those statistics, Senator Kennedy.
You haven't looked?
I did look in preparation for this hearing, but I didn't compare myself to others.
You haven't seen that you ranked the 7th the worst in the country in terms of making decisions?
You are the first to tell me this. And I think for me, I stress the quality of my decision-making. And as I explained, I came on, I was the first district judge to come on during this administration.
Yeah, but so were all the others. I mean, there have been 68 district judges confirmed in the 117th Congress. In terms of motions pending for more than 6 months, you rank number 3. You all came on at the same time. You all had the same problems with COVID. You're the 3rd worst. You really think of all the other district judges in the 7th Circuit, you're the one that ought to be promoted based on this record?
Senator, this is something that I've discussed with my fellow judges. Many of us new judges from...
I thought you said you'd never looked at these statistics.
I haven't, these particular statistics I am not familiar with. But in terms of new judges, both from the current administration and the former administration, we are quite a collegial bunch, and oftentimes talk about the pressures of a new judge and the way reassignments work in our district, which is that you get, for example, 300 cases.
Yes, ma'am, I understand. I'm familiar with the procedure in federal court. Here's what I'm trying to understand. Why is your record so bad?
Well, I don't view it that way, Senator. When I look at the quality of my decision-making, the feedback that I get from parties,
Well, of course, parties are not going to criticize you. They want you to rule in their favor.
I understand, Senator Kennedy.
I mean, that's just the way it works. Help me understand why you have such an abysmal record in moving cases. I mean, it costs a lot of money to litigate, and people are paying lawyers, and time is money. And of all the district court judges in the Seventh Circuit, you're the worst in terms of moving cases. Why do you think you deserve to be promoted over all of those others?
So, Senator, again, I'm not familiar with the statistics, but I stand by my record and that I give parties what they need. I think, I am regularly in my courtroom. I am regularly issuing decisions. I just came on at a very difficult time where there was a backlog in the courts.
So did everybody else. Let me ask you, when you were a partner in your law firm, you volunteered to write a brief on behalf of the Brady Center. You wrote the brief, and this is what you said. You volunteered for this. You weren't being paid. Is that right?
This was a pro bono case that one of my partners brought in, yes.
You said, quote, assault weapons may be banned because they're extraordinarily dangerous and are not appropriate for legitimate self-defense purposes, close quote. Tell me what you meant by assault weapons.
Thank you, Senator Kennedy. Just to clarify there, I was local counsel. Our Supreme...
Yeah, but you wrote the brief. Tell me what you meant by assault weapons.
Senator Kennedy, actually, I did not write the brief. The brief was written by...
You signed the brief, though, didn't you?
Correct. I signed the brief.
When you sign a brief, you're testifying to the court that everything in it is true, right?
Yes.
Okay. So they're your words in terms of the court, right?
Well, you're correct, Senator Kennedy.
Okay.
I would never
Tell me
sign...
what you meant by assault weapons.
So I am not a gun expert, and at the time, that brief, I think, was about 10 years...
You were giving the court advice about, say, ban assault weapons. What is... You told the court you were an expert. Just tell me what you wanted to ban.
Senator, sitting here today, as I said, I did not write that brief. I was local counsel.
Sign the brief.
I understand. At the time...
Tell me what you wanted to ban. That's all I want to know, Judge.
I don't remember the exact definition of assault weapons in the ordinance that was at issue.
So you submitted a brief to an appellate brief, you signed it, and you don't know what, and you said abolish assault weapons, and you don't know what you wanted them to abolish?
Senator, at the time that I signed the brief, I read the brief because our Supreme Court required an Illinois bar member to sign the brief. I was not responsible for researching the content.
You were responsible for the brief.
Absolutely, absolutely. And sitting here today, I do not remember the characteristics of that were cited in the ordinance for the assault weapons ban. It's not an area of practice that I have specialized in. I'm sure 10 years ago I could have answered your question.
And
but
Judge,
sitting here today,
you think
Senator,
you deserve to be promoted with this record?
Senator, I stand by my record. I stand by my record.
Senator John Kennedy's masterful interrogation of this judicial nominee exemplifies exactly what rigorous Senate oversight should look like and why thorough vetting of lifetime judicial appointments is absolutely essential. Kennedy came armed with facts, statistics, and receipts, transforming what could have been a rubber-stamp confirmation into a devastating exposure of incompetence and unpreparedness. His questioning revealed a nominee so fundamentally unqualified that her continued service even in her current position becomes questionable, let alone her promotion to a higher court. The brilliance of Kennedy's approach was in its simplicity and reliance on objective data. He didn't need to rely on political attacks or ideological disagreements when the numbers told the story so clearly. 125 undecided motions, 7th worst nationally, third worst for delays, exceeding 6 months. These aren't subjective opinions, they're measurable failures. When the nominee attempted to blame circumstances, Kennedy demolished that defense by noting that 68 other judges faced identical challenges, yet managed to perform their duties competently. This wasn't bad luck or difficult timing, it was individual failure. Kennedy's persistence in demanding actual answers rather than accepting political deflection demonstrated his commitment to ensuring only qualified individuals receive lifetime appointments. When the nominee claimed unfamiliarity with her own performance statistics, it revealed either willful ignorance or a shocking lack of preparation. When she couldn't explain what assault weapons meant in a brief she voluntarily signed, it exposed someone willing to advocate positions she either didn't understand or couldn't defend under scrutiny. The senator's questioning also highlighted the real human cost of judicial inefficiency. Every undecided motion represents people waiting for justice, families accumulating legal bills, and a system failing those it's meant to serve. Kennedy's emphasis on these practical consequences showed he understood that judicial performance isn't academic, it affects real lives. Most importantly, Kennedy's refusal to be satisfied with the nominee's repeated assertion that she stands by her record demonstrated intellectual honesty. Standing by an objectively terrible record doesn't make it good, it makes you delusional or dishonest. The American people deserve judges who can meet basic performance standards, explain their legal positions coherently, and take responsibility for their failures. This nominee demonstrated none of these qualities. Senator Kennedy's thorough dismantling of her qualifications wasn't partisan politics. It was essential oversight protecting the integrity of our federal judiciary.